The woman who wants to rig signatures, rig ballots, throw candidates off, is now threatening workers. She now has lost. Court of Appeals says, sorry, Jocelyn. You have no basis for doing any of this. So in order for this court to grant RFK Jr. relief, he's gonna have to find that the lower level court literally abused their discretion. So another judge has discretion and he abused it.
Let me first ask you for your reaction to what was charged yesterday by DOJ.
Well, look, it is the continuation of what we saw in 2016, what Russia tried to do in 2020.
Those were both fake hoaxes, moron. You remember Jocelyn Benson, the Michigan Secretary of State, the same woman who said that they were going to presume that signatures were valid, created a legal presumption of validity so that they don't actually have to check the signatures because they can just presume they're valid. Well, the court in Michigan said you can't really do that. Law doesn't allow you to do that. She's the same person who wanted to throw Trump off the ballots if they were successful in Colorado. She was absolutely going to throw Trump off the ballot in Michigan. And she is now in this video warning people, if you're working on the election and you even think about challenging any of the work that we've done here, you better watch out, and threatening them in this short clip. Now, in addition to this, she wanted to keep RFK Jr. off the ballot when he was a threat to the Democratic Party. And now that he is going to be supporting Trump, she wants to keep him on the ballot so that RFK Jr. can pull the votes away from the president. Well, Jocelyn here, this woman who is not in office in the interest of justice or a safe, sound democracy with free and fair participation, the woman who wants to rig signatures, rig ballots, throw candidates off, is now threatening workers. She now has lost. Court of Appeals says, sorry, Jocelyn. You have no basis for doing any of this. And this has been a repeated pattern from her because she's a partisan hack. So here's the threat. Before we look at the appeal, here is what she sounded like before RFK Jr. obliterated her in court.
If someone were to violate the law and not certify the election at the local level, we will come for you.
Ugh.
So any local certifier thinking of skirting the law and not certifying the vote, don't even think about it because we'll come get you. Now, did you hear that little psychopath music they layered over this? If she doesn't already look like enough of a psychopath, and they all kind of do, not to make it about looks, but physiognomy is important, and you can tell a lot by how a person comports themselves. So that's one man's opinion on that. But here is Jocelyn. Here's the music again. Listen. Someone were to violate the law and not certify the election at the local level, we will come for you. So any local certifier thinking of skirting the law and not certifying the vote, don't even think about it because we'll get you.
Because we'll get you. She's a psychopath. Did you hear that? And that psychopath music also on there just confirms it. So she's the same woman who was explaining that she wants RFK Jr. now to stay on the ballot, and she wants a presumption of validity for all signatures so that she doesn't have to check anything because it's presumed valid. So when Liz Cheney's signing a bunch of ballots over there, she can just shove them in. So here is the Court of Appeals opinion. You see, this case is Robert F. Kennedy Jr. versus the Secretary of State, Jocelyn, the "we'll get ya" woman with the Disneyland music behind her. Coming from the Court of Appeals of Michigan, published September 6. By these judges, it's a per curiam opinion, which means it's the opinion of the court. No single judge is taking credit for the opinion. The judges write, the plaintiff here, RFK Jr. in the House, he appeals and he declares injunctive relief because they are keeping his name on the ballot, right? The lower level court of claims said, no, your name's on the ballot. Says RFK Jr. wanted to remove his name from the general election ballot, but Jocelyn, the secretary, denied his request, said, no, you're staying on because you backstabbed our Democratic Party, so you're staying on. Everybody can vote for you in protest, and we're just going to throw those votes in the garbage. Now, because the statutory prohibition against candidate withdrawal cited by Jocelyn, because she picked some law out of her butt, because it does not apply to RFK Jr., we reverse and we remand for an entry of an order granting immediate relief to RFK Jr. Jocelyn Benson loses. So here's the background. Now, RFK Jr., he sought and got the nomination of the Natural Law Party, right? So he went through them, independent, joined their party, got on the ballot in Michigan. In April, the Natural Law Party filed a certification and listed him as their nominee. So then in August 2024, RFK Jr. suspended his presidential campaign. On August 23rd, Bobby wrote a letter to Jonathan Bratter. Bobby's going to be RFK Jr., so the director of Michigan Bureau of Elections, and he asked that his name not appear on the ballot. Bobby informed Director Brader that he intended to withdraw from the election. I'm not going to participate. Please take my name off. So Jocelyn Benson then responded in a short email on August 26 and declined to accept RFK's withdrawal. Says, sorry, you're going to stay on the ballot. And so according to Jocelyn, she said, well, I found some citation, some law, this statute 168.686A2. It says Michigan election law does not permit minor party candidates to withdraw. Sorry. Says Jocelyn has made no effort to rely on that subsection once the litigation in this matter began. However, it appears by all accounts that the subsection does not even apply to Bobby. After additional email exchanges, Jocelyn, so they said, we're ridiculous. Lawyers send emails back and forth, blah, blah, around and around we go. She again said, no, sorry, Bobby, you're not going anywhere. You're going to stay on this ballot and it's going to stink for Trump. Now, this time she cited Section A4 and stated that in her estimation, Bobby could not withdraw his name from the ballot at all. Different section. So then RFK Jr. filed a complaint in the Court of Claims, and he sought mandamus relief, right? He asked the court to do something, mandate something happen, mandate my name come off the ballot. Bobby filed his complaint after hours on the Friday of a holiday weekend, Labor Day weekend. The complaint was docketed on September 3rd. That same day, and without receiving an answer, the Court of Claims denied relief in a written opinion, all right? So an answer meaning the state didn't even respond. The government didn't respond. So you can see just how corrupt all levels are in this unfortunate state. But the Court of Claims, they get it. It comes in the same day, right? They receive this complaint. Normally, the complaint's against the government. So if you're a court, you'd hear from the government, hey, they have a complaint against you. Would you like to answer this complaint? What's your position on it? Okay, yeah, so we're going to set a deadline. Complaint received. Government has 10 days to respond. Schedule a date on the calendar. Government, you have notice of this complaint. They serve the complaint on you, and now they're going to get this delivered, 10 days from now, and everybody has a time to make their opinion heard. The Court of Claims relied on MCL 168.686A4, which again, she changed a little bit. So remember, you can see the difference here. It goes from A2 in her first email. So Jocelyn's like, oh no, A2 sounds good. Pick that one. Her team is over. And then they're like, well, actually A4 is a little bit better, right? You can see they switched it to A4. So we're going to use that one instead. So the Court of Claims didn't even wait for the government to respond. They just said, no, sorry, Bobby, you're done. Get out. They said that they relied on the A4, which was the updated version, in support of its conclusion that Bobby was not entitled to have his name withdrawn. So then Bobby filed his claim of appeal, RFK Jr. Now, along with his appellate brief on September 4th, very fast turnaround, 10 p.m. Consistent with this court's order, Jocelyn has filed her appellee brief on an expedited basis. So then RFK Jr. submits his, she files hers, and we're ready to go. We've got both sides now that are up to speed. Court has both drafts. We're ready to go. It says, at its core, Bobby, RFK Jr. contends that he is entitled to a writ of mandamus. He's entitled to have the court say, take my name off the ballots, and then everybody in the state follow that order. This court reviews for an abuse of discretion the trial court's decision whether to grant or deny this relief. So did the lower level court, right? Sometimes we ask ourselves, we hear different phrases like you can only appeal and reverse if there is a manifest injustice, which is one standard. Or you hear another standard called de novo review. And de novo is like, we're going to look at it fresh with a fresh set of eyes, like it's a brand new case landing on our desk. It's kind of a benefit if you're appealing it. But if you're appealing it and the standard is manifest injustice, you're only going to get relief and we're only going to reverse if it's a manifest injustice, like, oh crap. As the person appealing, you have a real high burden, a bar to hit. This is a high standard too, abuse of discretion. So in order for this court to grant RFK Jr. relief, he's going to have to find that the lower level court literally abused their discretion. So another judge has discretion and he abused it. They say mandamus is an extraordinary remedy that will only issue if the standards are very high. The court is not going to just mandate, order people to do things unless there's very good cause to do it. That's why it's an abuse of discretion standard. So here's what RFK Jr. had to show, and as we'll see, he did. That they had a clear legal right to the performance of a specific duty, that the defendant, in this case Jocelyn, had a clear legal duty to actually do the thing. The act is ministerial, right? There's no other adequate legal or equitable remedy that might achieve the same result. results. As an initial matter, Jocelyn Benson, the secretary, she argues that Bobby's complaint is barred by the doctrine of laches. Now, this matter was not even raised before the Court of Claims because the court issued its opinion before Jocelyn had the opportunity to even answer this, right? So now she's like, well, on appeal, I'm going to bring up laches, which is like you should have brought this claim earlier. It's too late and you're out of luck. Now, they note that the statutory deadline, Jocelyn says sorry, but they didn't bring this up in the lower level court because there was no time to do that because the court just said sorry. They say Jocelyn notes that the statutory deadline to send county clerks the list of candidates is Friday, September 6th. So she's like, it's too late. Sorry, you're already in on this. And she says that this section requires notice at least 60 days in advance of the election. So she's like, sorry, you got it in too late. You didn't get your notice in time. So Jocelyn also asserts that ballots must be printed almost immediately after this deadline. She's like, we're printing ballots like on the 7th, basically. It's like immediate. And so if you don't tell us by the notice deadline, then we have to start printing these ballots because we got to print a bunch of absentee voter ballots, militaries, and overseas ballots. And so Jocelyn, the secretary, contends that Bobby engaged in an unreasonable delay. So if you delay, right, if you're the cause of the delay and then you suddenly request a remedy, you don't get it because you caused the delay. That's laches. And so that she says, no, he waited too long to withdraw. He waited over 4 months after he got the nomination. And she says that his conduct was dilatory, right? So he was delaying almost to get an advantage. And then now, since he delayed, we're not going to give him the benefit. So they say, all right, well, that's her position. And she just raised that in the appeal since the lower court didn't even consider these items. But the court gives us some analysis and says, all right, let's talk about laches. You want to talk about it? That's fine. Says the equitable doctrine of laches can be applied in election cases to bar untimely challenges. So yeah, you can use this. We've got other case law that says you can. Here was one. One case said, when no acceptable explanation is proffered for a plaintiff's delay, when you can't accept, why were you delaying? A plaintiff's requested relief should be barred by unexcused laches. Now, lawsuits that are filed in election matters are especially prone to causing harm to the public and the integrity of the process because the closer that we get to the election, it might make laches appropriate in some matters. Now, on the issue of laches, they're giving us some law before they do some analysis on how this all applies. They say, speaking of laches, it should be acknowledged that RFK Jr. did wait 4 months after his nomination to try to withdraw. He did. Now, at the same time, however, it's not apparent that he delayed in withdrawing. So once he made the decision to withdraw, he withdrew like very quickly. He was running and running and running, and then he withdrew. And this happens every election. It's kind of what happens in elections. People run, someone wins, everyone else drops out. And there's no evidence in the record about when the desire to withdraw arose. It's not like he desired to withdraw 4 months ago and then waited and waited and waited. He made the announcement with Trump, filed the paperwork immediately, beat the notice deadline. That's it. Now, in addition, it cannot be denied that RFK Jr.'s name appears to have tarried somewhat in his attempts to obtain relief in both the Court of Claims and in this court, but nevertheless, the trial court was able to render its decision in time for Jocelyn to comply with her statutory duties, notwithstanding the delays. So she could have done it. Even if there was a little bit of a delay, you still should have been able to comply with this, and we were able to do so as well. So furthermore, the law generally favors merit-based decisions, not based, right? So we actually want to hear the claim and hear the argument. We don't want to just find like, oh, that's a deadline, or this is a technical clerical reason why this can't happen. So accordingly, we reject Jocelyn Benson's, the Secretary of Michigan's, laches argument. Not appropriate here. You could have complied with it. It's not too late. There are deadlines. Like this happens all the time. So turning to the merits now of the question involved. The parties direct the court's attention to statutes that pertain to the nomination process for presidential candidates. So the laches thing, which was just brought up out of nowhere, is not going to be sufficient to get the mandamus, to get the mandate to take the names off the ballot. For instance, the parties briefing, they reference 168.686. The statute is pertinent to an extent because it provides for the nomination process. However, the statute itself is silent on the issue of withdrawal. Now, Jocelyn, the secretary, she takes the position that the answer to the withdrawal questions is found in the subsequent section, which is 168.686A. Now, in general, the process for nominating a party candidate is in A. And by all accounts here, Bobby was nominated by what this state's election law refers to as a minor political party. So Bobby is in that category. Now, the statute says that if a political party entitled to a position on the ballot failed to have at least one candidate who polled at least 5% of the total vote cast for all candidates for Secretary of State, a last preceding election in which a Secretary of State was elected, candidates for that political party shall be nominated nominated as provided in 532. Meanwhile, 532 says, in a circular fashion, right, just poor statutory drafting, that the nomination of a minor party candidate shall be made by means of caucuses or conventions, which shall be held in the names of the party nominations filed at the time in the manner provided in 686A. So you see how that works? So it's just kind of poor drafting. And this happens in the law because we have dummies in our legislature. Now, as directed by 532, okay, so Jocelyn originally cited 686A2 to deny Bobby's request to withdraw, but now it appears to have abandoned that subsection. Now, given that this subsection applies to county caucuses, and given that it refers to other offices other than the office of the president, the court agrees with the defendant Jocelyn that this section does not apply at all. So she cited a bad subsection. Defendant now relies on MCL 168686A4. Now they changed it. That subsection pertains to the nomination of minor political parties and provides as follows: the state convention shall be held at the time and place indicated in the call. The convention shall consist of delegates selected by the county caucuses. So we're reading this now. And it says here in italics, the convention may nominate candidates for all state offices. District candidates may be nominated, blah, 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 fast forwarding. Candidates so nominated and certified shall not be permitted to withdraw. And so they're saying, oh, that's the one. We found that language. Now, Bobby says, hold on a minute. That only applies to state offices, right? When you read all of this, because it says that right here. The convention may nominate candidates for all state offices. State. He's not running for a state office. He's running for a federal office. And that its prohibition against withdrawal does not apply to candidates for the presidency. And they say, yeah. The court says, yep. In light of the plain and unambiguous language of the statute, we agree. As the plaintiff, Bobby, notes, the fourth sentence of this says literally all state offices. It literally says that in the statute. This is 168.686A4. This is what Jocelyn cheating Benson was trying to keep him on the ballot, originally tried to keep him off the ballot, now wants him on the ballot, and says it's for state offices. So she tried to sneak this through and say no, right? Because she's a cheater. It's clear. The office of the president is not a state office, not even close. It's a federal office. The text of the statute does not mention any federal offices at all. And this is significant because the prohibition against withdrawing applies to candidates so nominated. And when you read that with our other case law, it's apparent that the phrase candidates so nominated are those that are nominated by a minor political party for all state offices. It matches this case law. And so it's not controlled by this. The nomination process for the office of the presidency is controlled by not subsection A, it's controlled by 686 plain. Unlike A, 686 expressly mentions nominations for the president. So there's another subsection that Jocelyn just ignored. Now, Section 686 does not contain the prohibition against withdrawing. So 686A4, it does have a prohibition against withdrawing because that's for state offices. But when you're in the federal office, there's no prohibition in there. In fact, 686, the one that applies to the actual office of the presidency, does not mention withdrawal at all. And so we find that that omission of the prohibition is significant and find that it demonstrates that the legislature did not intend to constrain candidates for the office of the presidency in the same manner as candidates for state office. Generally, when language is included in one section of a statute, but it's omitted from another, we think that was done on purpose. And so the legislature made clear that 686, they wanted that to restrict the ability of state candidates to withdraw, but not restrict the ability for presidents to withdraw. And without that restriction, if that restriction is not in the law, because it's not in the law, Jocelyn had no basis to deny RFK's request to withdraw his name from the ballot. No reason at all. And the lower court did it. So while not even argued by Jocelyn, we note that the circular references between 686 and 532, we note that they exist. This is a statutory problem. In particular, 532 refers to all candidates nominated by political parties, and it refers to 686. However, 686A4 only refers to candidates for state offices, and that's what she's relying on. When construing these provisions, we must read them in a manner that's consistent with one another. And so here, we construe these statutes to mean that 686A4 is the state offices statute, not all offices in general, because it says all state offices. Any contrary conclusion would require us to overlook 686A4's express limitation to state offices, which we cannot do. Now, Bobby sought to have his name withdraw from the ballot in conclusion, in advance of the upcoming election. Now, while the request was made close to the deadline for Jocelyn to give notice of candidates to local election officials, Jocelyn's like, well, that deadline is very important to me. It was not made so late that latches should apply, that it's past the point of no return. Additionally, we conclude that the absence of any statutory authority prohibiting withdrawal gave RFK Jr. a clear legal right to have his name removed from the ballot. Jocelyn had no ability to disregard that request, but she did, because she's a partisan hack. And at this point, no other remedy aside from a mandamus, an order from this court, is available to RFK. There's an impending deadline for Jocelyn to send notice to local election officials. And finally, removing RFK from the ballot is a ministerial task. All it is paperwork. And so accordingly, we hold that RFK Jr. is entitled to this mandamus relief, and that Jocelyn, Benson, leftist Democrat hack, shall remove Bobby's name from the ballot as requested. And so we reverse and remand, and we demand that the lower level court enter an order granting immediate mandamus relief. This order has immediate effect. We do not retain jurisdiction. Signed by these great judges, Michael F. Godola, Mark J. Kavanaugh, and Mark T. Boonstra in the House. And they're entitled to immediate relief. They're not even going to address RFK Jr.'s other response. And a great opinion, the right opinion. Jocelyn Benson is a partisan, corrupt Secretary of State. She is there with one purpose in mind, which is to deliver the state to the Democrats. Now, this is good news. It's also happening elsewhere. You can see the North Carolina State Board of Elections also orders RFK Jr.'s name removed. Another victory here, but he did have a setback in Wisconsin, trying to get his name off the ballot, but the North Carolina State Board of Elections has filed an appeal, right? They really want to keep him on the ballot, but the Court of Appeals, they issued an order granting Kennedy's request to stop the mailing of the ballots that had his name on it. State election officials were racing to start sending out the first absentee ballots, racing. His name's on it. Get him out, get him out, get him out. If they can get him out faster than he can get him off, then they'll get a bunch of those ballots out. The court was a 3-judge panel. They ruled unanimously. They also told a trial judge to order the State Board of Elections to distribute ballots without Kennedy's name on them. No legal explanation was given. They just did it, right? It was trying to find a big opinion like we just read, couldn't find one. But the NCSBE said in a statement, it would still work through the weekend to code new ballots without Kennedy's names. Proofs will also be provided. The state board notes there are more than 2,300 different ballot styles statewide, which is kind of nuts. 2,300 different ballot styles for all the different races? Wow. And that more than 2.9 million ballots had been printed before the Court of Appeals order. So all those can be shredded now, thanks. The board notes that the state elections director, Karen Brinzel Bell, had told county officials not to send ballots yet, wait until a date. The state board said on Friday more than 136,000 voters had requested absentee ballots, 13,000 military and overseas voters, right? And they wanted Kennedy's name to be on those ballots, but not now. The NCSBE notes voters who have already requested a ballot do not need to request a new one. If a voter needs their ballot to be delivered to a different address, the voter should complete a new form. So Michigan, we just read through that opinion. They did the same thing, and they are not happy about this, all right? The left is upset. You can see Dana Bash had on this guest. This woman says this is actually costing our election system, and it's interfering with our election system. What? To have a candidate withdraw, as is ordinary in a regular election? Candidates withdraw all the time. How is this interference with the election?
You know, RFK Jr. fought to get on the ballot as a political party in our state, and we believe that what we're seeing right now is actually a cost at our election system. You know, ballots, to your point, were supposed to go out today, and we had a Republican Court of Appeals that came in and stopped that decision or halted that from happening to get RFK's name removed from the ballot. And what we're seeing right now is a great corruption in our Court of Appeals with the Republican takeover there. But we're also seeing that in the sense of this is going to cost election or voters in North Carolina potentially millions of dollars and having to reprint these ballots.
And Anderson, obviously, you make the legal argument and the expense argument, but there's also a political argument. I'm just going to go out on a limb and say you would not be arguing for him to stay on the ballot if you didn't think it would hurt Donald Trump.
We're arguing for him to stay on the ballot in the sense of that ballots are supposed to go out today. It's egregious, in my opinion, that a Court of Appeals came down with the decision that on the day that ballots are supposed to go out to stop this. It's interfering with our election system and the integrity of it right now, which is why we're fighting back against this.
Okay, so obviously Dana asked a good question. She knows it's going to hurt Donald Trump, which is why they want his name on the ballot. Suddenly she's a stickler for the calendar. She's like, we had an appointment to send him out this day. No, you are upset because now the name's going to come off the ballot and people are not going to be able to siphon votes off away from Trump. So it's transparent as can be, but we've got more here. You can see we've got Dan Goldman, the man who has increased increase his wealth, running as a congressman, the man who basically bought his congressional seat as an heir to the Levi Strauss family, hasn't really accomplished much other than that, other than working for the government, definitely needs to tuck in that collar. Someone should have alerted him to that. But this happens all the time. Here's Dan Goldman.
Congressman, let me first ask you for your reaction to what was charged yesterday by DOJ.
Russia, Russia, Russia.
Well, look, it is the continuation of what we saw in 2016 and what Russia tried to do in 2020.
Those were both fake hoaxes, moron.
And now it's confirmation that Russia is trying to, once again, meddle in our election, our presidential election, and that it's clear it's trying to do so to support Donald Trump, who should also be included in the category of, at minimum, a useful idiot for Vladimir Putin. I think a little bit more disquieting to me, at least, as someone who sits on this so-called weaponization of the federal government subcommittee in Congress under Jim Jordan's chairmanship, is that they have spent this entire Congress attacking the government for trying to stop malign influencers like Russia and using euphemisms like censorship and efforts to interfere in the First Amendment, also that they could pave the way for Russia to do exactly what it has now been charged with doing and sanctioned for doing. And so I'm not making any allegations that they knew about any of this, but I certainly have been banging the drum that the point of this subcommittee was to chill the government from having any interactions with social media companies in order to stop election interference.
Wow.
And now we see exactly what we're talking about.
What a little monster dictator. Unreal. So he's out there saying, no, we need to censor you. That's why the FBI was working with Elvis Chan, who was the FBI agent working with Facebook. That's why we stood all of that up. We need to do that because Russia, Russia, Russia. And he goes back to 2016, which he must think is still real. I don't know how he thinks that, or he's just lying to you. Same thing with 2020. Now he's using this one again. They're regurgitating their prior meals. This is season 3 of the Russia collusion nonsense, and they cannot let it go because it's all they've got. And it is troubling when they start coming after people who are just sharing opinions. Every other group in the country can exist. Well, white males obviously don't have any groups. You could have, like, Hispanic Americans, Asian Americans, African Americans, all sorts of PACs representing all sorts of other countries that exist all over the place. But if you have Russians that share opinions in America, suddenly that's verboten. Do we declare war against Russia? I don't think so. And we'll be here to continue to cover it, my friends. And so thank you for subscribing wherever it is you're watching this. We've got another great segment coming up, but we're wrapping this one up. We want to thank you for joining us on this segment and for subscribing, and we'll see you back here on the next one.